This is DevAI, focusing on news developments in AI and legal space. Please subscribe to my channel. The case Google vs. Gonzalez is a major Supreme Court hearing case about whether YouTube can be sued for hosting accounts from foreign terrorists. But its much bigger underlying question is whether algorithmic recommendation should receive the full legal protection of Section 230 since YouTube recommended those accounts to others. While everyone, from tech giants to Wikipedia editors, has warned of potential fallout if the court cuts back these protections, it poses a particularly interesting question for AI search, a field with almost no direct legal precedent to draw from. In November 2015, a series of coordinated terrorism attacks occurred in Paris. At least 130 people were killed by the terrorists, and the Islamic State took responsibility for the attack. Among those killed was a single American 23-year-old student Nohemi Gonzalez on an exchange program with California State University, Long Beach. Her family began to seek legal remedies against Google, the parent company of YouTube. The suit argued that through its recommendation system that tailors content based on user profiles, YouTube led users towards recruitment videos for the Islamic State and were partially responsible for Nohemi's deaths. Google defended itself by relying on Section 230, passed as part of the Telecommunications Act of 1996, which provides immunity from content published on an internet service provider's platform by third-party users. A lower court ruled in favor of Google, and the decision was upheld by the Ninth Circuit Court of Appeals. In their appeal to the Supreme Court, the family focused more on the YouTube algorithm that has been tailored to deliver content believed to be of interest to the end user, arguing that while this was automatically done, it was a form of moderation that Section 230 does not fully cover. They wrote in the petition to the Supreme Court, whether Section 230 applies to these algorithm-generated recommendations is of enormous practical importance. Interactive computer services constantly direct such recommendations, in one form or another, at virtually every adult and child in the United States who uses social media. The question is AI liable for terrorism? And the Supreme Court granted certiorari to the case in October 2022, along with a related case, Twitter versus Tamni, also dealing with Section 230 and terrorism-related content. They will be the first cases that the court will hear over Section 230, which since around 2015 has come under increasing partisan criticism towards big tech. Justice Clarence Thomas had spoken to a need to review Section 230 in previous dissenting statements to court orders, arguing that social media companies should be regulated like common carriers, which would prohibit content-based discrimination. Many of the big tech companies provided their own amicus curiae to support Google's recommender system as part of the case, as well as smaller sites including Reddit and the Wikimedia Foundation, which rely on moderation systems that partially incorporate user moderation as part of their system. While there is a general support for updating Section 230 to reflect modern concerns, these briefs broadly stressed the need to let Congress pass legislation rather than having the Supreme Court issue its own judgment. This position was upheld by Ron Wyden and Christopher Cox, the lawmakers behind Section 230, and law professor Eric Goldman, who has written extensively about Section 230, in addition to mobile app platforms like Yelp and Craigslist, and free speech advocacy groups like the ACLU and the Electronic Frontier Foundation. Oral arguments in Gonzalez were held in February 21, 2023. Observers to the count found the justice from both liberal and conservative sides questioning the issues around algorithms, stating that most internet services are based on algorithms. The justices also questioned whether YouTube's algorithm was specifically tailored to promote terrorism-related content. The justices were not sure it would be possible to delineate content further, and the potential for massive lawsuits and economic impact should Section 230 be changed. Justice Amy Coney Barrett suggested that the result of the related Twitter case may help to resolve the case against Google. The Supreme Court case will be very interesting to watch. Precedents around people lightly editing posts by hand will only offer a limited guidepost for complicated large-scale AI-generated writing. Courts could end up having to decide how much summarizing is too much for Section 230, and the decision could be colored by the political and cultural climate, not just the letter of the law. Judges have interpreted Section 230's protection expansively in the past, but amid an anti-tech backlash and a Supreme Court re-evaluation of the law, they may not afford any new technology the kind of latitude earlier platforms got. But as courts reconsider the fundamental of internet law, they're doing it at the dawn of a new technology that could transfer the internet, but might take on a lot of legal risk along the way. This is Dev AI, focusing on the newest developments in AI in the legal space. Please subscribe to my channel and put any questions or feedback in the comment section. Goodbye.